Good afternoon, here with the HR quarterly updates from Pallas Employment Lawyers. My name is Maarten van Kempen, here together with
Niloufar Rahimi.
And today we will do with you the following topics. As usual, we will do some updates on employment legislation. We'll do some recent case law. And we have a special topic for you today, which is the non-compete clause. And we all know why, because we are having lots of troubles here on the labor market, finding the right employees. I will do the updates on employment legislation and the recent case law, and Niloufar will do the non-compete topic with you. Please let us know if you have any questions. They will come via the tablet through us, so we'll be able to answer them if you so require. First of all, employment legislation. Not that much legislation at hand at the moment, but one topic that we would like to catch your attention, which is a bill which is going to restrict the compensation scheme of transitional allowance in the case of the dismissals of long-due disability. The point is that since the start of this legislation, which was in 2015, the transitional allowance came into effect, and it was granted to every employee who was dismissed, regardless the ground. And one of these grounds, of course, was this long-term dismissal. And before 2015, there was no such compensation in place, and that actually led to the following situation in which employers actually decided not to dismiss these employees because they were not willing to pay these transitional allowance, especially when it concerns elder employees with long labor history at the company. So what happened at that time was that government decided to set up a compensation scheme for these transitional allowances, meaning that the UWV would compensate employers for the payout of this. And that led actually to the specific situation in which, at that time, employees started litigating against their employers to get a dismissal. Because employers were still reluctant to dismiss the employees because they were not certain whether or not they would receive such compensation, and it actually led to the Xella Supreme Court ruling, in which the court ruled that indeed employers following the good employership were to grant a dismissal if an employee would choose so. And the fact that the court did that at that time was the fact that this compensation scheme came into effect. So what's going to happen now? You know now that, of course, you can apply for compensation by filing a form at UWV. It's for long-term illness, at least 2 years. And the new situation now is that actually, government has been paying out for almost 3 billion euros in the past 10 years for compensations. And government now has looked into that and said, well, this is far too much, and they are going for savings. And they are going to get these savings, they're trying to get a saving of around 380 million a year by actually limiting the number of companies that will be entitled to this compensation. And that means that this compensation will, if it's up to the government, will only be granted to what we call small employers. And then the question arises, okay, what will be a small employer? Well, it's actually quite simple. You could say that companies with 25 or less employees will be considered a small employer, and only for that group of employers this compensation will stay in place, meaning that all other employers in the Netherlands, as from 25 or more, will not be entitled to this compensation anymore. That should lead to a structural saving of 380 million euros a year. What's the status of this legislation? Well, at the moment, an internet consultation has come up. It started on February 19th, so 2 weeks ago, and it will finish, in the next 2 weeks, March 19th. And of course, now the first responses on the internet consultation, of course, you can imagine are a bit, let's say, negative. Most responses are, of course, that, well, we had this compensation, we didn't have to pay 10 years ago, there are other ways to find your savings, etc., etc. Anyway, this consultation will be in place until March 19th, so if you have some sort of opinion, please feel free to respond, because the internet consultation is free for everybody to respond.
Yes.
If you agree or not agree. It's the intention of government to have this legislation in place as per the 1st of July 2026. That brings me to recent case law, and the most important case law to be discussed here is, of course, the recent case of Uber, the taxi company. And the Uber case, of course, I'm sure that many of you will have read about it, and maybe many of you will already be puzzling what should we do with it. So let's give you an update on that. The context of the Uber case is actually how to determine whether a working relationship qualifies as an employment contract or not. And the difference between being in an employment contract or not has, of course, consequences on being an employee, meaning entitled to holidays, payment during illness, dismissal protection. Of course, you have, as an employer, all the costs of the insurance for social employee insurance schemes like the BW, ZW, VIA, etc. And of course, you have the tax-related issues, which means that you have to withhold wage taxes. Then, a very important part, of course, may be pension and collective labor agreements, which may enter into place if a certain working relation is to be considered an employment contract instead of a regular contract. And this discussion has been going on now for many, many years. And the last important Supreme Court ruling we had on this was also Deliveroo, and in Deliveroo it was said that to determine whether this contract is to be considered an employment relation or a regular contract relation, it has to be done by, okay, what have people actually agreed upon? What's in the contract? And of course, what's the meaning of parties when they entered into the contract? And of course, the intent and the interpretation. So that was step one, which was set out in the Deliveroo court ruling. And then, of course, there was step two, because when you then had actually set this agreement in place, then of course you had to check, does it fall under the scope of the employment contract regulation, which falls under Article 610 of the Dutch Civil Code, or is it a regular contract, a specific contract, which falls under the regulations of 400 of the Book 7 of the Dutch Civil Code? And there is a bit of a difference between the two contracts. And most important here, of course, is that you look, okay, what kind of work is to be performed? Is this work to be performed under the employer's authority and control? And is payment made? Is wages or salary paid? But if you look at these three criteria, we see a little bit of the same criteria for both employment contracts as the regular contract. So how do you determine which is which? So in the Deliveroo Supreme Court, which was already ruled 2-3 years ago, the Dutch court gave the employment law practice a sort of hard and fast rules. So what are you going to look at? So first, of course, nature and duration of the work. If the work is for a short period, maybe it's more a regular contract than an employment relation. Of course, who is actually controlling the task and working hours? Is that the employer or is it the contractor who can make that out for himself? How is your position integrated in the company? Do you actually do the same as a colleague who is under employment? Do you have to do the work specifically by yourself or not? How was the contract formed? Was it something that was the contractor put up with it by the employer, or was there a really mutual discussion about how it was to be formed? So tell us about how the compensation was structured. Is VAT, for example, part of the payment? Is anyway regulated for illness? Is there those kind of stuff? And very important in that delivery court ruling was, of course, is there any sort of business risks and entrepreneurial behavior on the side of the contractor? Can he be considered an entrepreneur? And how do you look at that? Well, that could be reputation, client acquisition, the tax status, the number of clients, duration of assignments, how many assignments, do you have several assignments at the same time, do you have several assignments over a year? All those factors should be taken into account. And this specific Deliveroo Supreme Court ruling led to new discussions in labor practice because there was still unclarity about entrepreneurship. Why? Because you had the situation in which, let's take a hospital which has employees taking care of patients, and it also has contractors doing exactly the same kind of work during the same working times, but they were contracted via a contractor agreement. So how should we cope with that? And that meant that in the past year and a half, this decision came more in effect, especially also because the tax authorities started to check on these relationships, because if you're an employee, then the company will have to withhold wage taxes. And if you are considered an employee, then the pension funds may come in and say that you have to pay pension premiums. So there was still this difference between the contractor and the employee, and there was actually a line going up, and it's also something that the tax authority took as a stand. If you actually do about the same as the employees, then you're probably an employee. And that is actually what the Uber case was all about. The Uber case was about taxi drivers who were supposed to work, of course, in the taxi. They were getting their assignments via software, and they were, of course, allowed to refuse one. But if you would refuse a client, then of course you'd go down and you wouldn't receive any client after all. So FNV started litigations against Uber, stating that these people actually were under an employment contract. And the cantonal court said, yes, they are. Uber appealed and they went to the Superior Court. And the Superior Court said, well, we don't know this actually. So they said, okay, let's ask the Supreme Court some specific questions. And the most important question was, how do we take this entrepreneurship as a specific insight, whether or not Uber drivers are to be considered a contractor or an employee?
We have a question.
We have a question.
From Grace, how does that relate to eigen risicodrager?
Well, if you're a contractor, then I don't think you have problems with the eigen risicodragerschap, because the eigen risicodragerschap has to do, of course, with the
illness,
the ziektewet, illness.
Yeah.
let's continue. This entrepreneurship was the question, because if these drivers are actually doing the same work as the people who are employed, because that was the feeling, and also the feeling of the tax authorities, then that would probably be an employment contract. And okay, what did now the Supreme Court say? The Supreme Court said, no, it is possible that a contractor and an employee who actually do the same kind of work can do that under different contracts. So the fact that most of these people are doing this under an employment contract doesn't mean that these contractors also are employees. You have to take all circumstances into account, and one of these circumstances is whether or not such a contractor is actually an entrepreneur. And that means, knowing that, what does it mean after Uber? Where are we now? Because we have tax authorities who are still checking on this holistic approach, which means that if this work is also carried out by regular employees, then the tax authorities may consider these people also as an employee. And that, of course, very likely that you as employers are quite reluctant to offer people contracts as a contractor. And that gives also problems, because that means that many people who actually only want to work as a contractor may not be interested in working for you anymore. But this specific case law may give some guidance how to continue. For example, we know now from Uber that platform workers and also others in full self-employment are more likely to be seen as employees if there's a digital control, and there it is, a limited business risk. The limited business risk, of course, is of importance, because you have to be an entrepreneur.
Exactly.
The emphasis is also the actual working situation, which you're really doing, and not only what's stated in the contract. Well, that's of course not completely new, but employees are also better protected against false self-employment, while employers must better substantiate that someone really works independently. And that means for you as employers that it is, I think, you have more possibilities now, given this Supreme Court decision, to start working with contractors. But make sure that the people that are contractors do have business risk. They should be entrepreneurs. It is something that you really should look at, which also means limit the length of the contracts. I would say less than 6 months.
Yes.
If you take them less than 6 months, there's not a certain continuity.
And
this continuity does mean that there's not much limited business risk.
Yes, and maybe also limit the scope of the work, a clear scope of what they're doing, and not the same work as any other employee.
Absolutely.
Maybe on project basis.
Yes, absolutely. Absolutely.
Okay,
now I understand the question, because
great.
the eigen risicodragerschap was of course for the first part. It still the eigen risicodragerschap and this limitation of compensation transition allowance doesn't have anything to do with it, because eigen risicodragerschap means that an employer has to pay the ziektewetuitkeringen themselves, or the WGA.
Exactly.
That's what we're talking about. And when we're talking about the limitation, we're actually talking about the transition allowance, which is the compensation that an employee receives when they're getting fired. Yes. And that, of course, that the height of that compensation is related to the years of service and the salary.
Exactly. There's another question.
Yeah.
Can you give an example on how to better substantiate that someone works independent?
Yes, I think you can. For example, take what we're now looking at, for example, is interim work. Interim managers, but also interim HR professionals, for example. You do have interim HR professionals who actually have this interim business as their business, which means they're here for 4 months, then they're there for 6 months, then they're for 3 months. Sometimes they have 2 or 3 assignments at the same time. But by limiting the scope and also the timing of the contract, so what you don't want to have is, let's say, the example of the ICT professional, which has been working as a contractor for more than 5-6 years at the same company, because then of course you see that's something that may be a business helping out for a certain period of time, may come into getting dependent on this employer, and also meaning limited business risk. And the business risk is by getting short assignments, finding the next one.
Exactly.
That's where the business risk is.
Yes, and it's also maybe good to take into consideration that there's an internal and external entrepreneurship. And yes. Externally, if the contractor you are hiring has a website, is registered at the Chamber of Commerce, etc., that also helps to substantiate.
That has to be. You have to be a real entrepreneur.
Yeah,
and that's something you can check. So you'll have a VAT number, you'll charge VAT, but for the working relationship, it is very important, of course, that also maybe a way of looking at it is contractors should be judged on the output. Employees are mainly judged on the input of what they do. So that's also one of the ways to look at these things. So, for example, an interim HR manager, if the assignment is okay, we want you to do a certain project for a certain period of time, then it would be best to make the timing and the ending of the project make them in a combination. So make sure that people are being put in specific projects, and that's also a possibility because, for example, if you have an HR department and you have a pregnancy leave, for example, a maternity leave, that you take out certain tasks of this HR department, give them to the other employees, and get a specific project for the interim HR manager. That could be one of the possibilities to substantiate such a contract position. But I think it's more difficult if you're looking at, for example, the care sector or the teaching sector, where you're just one of the people doing the same work. There we see probably more doubt whether or not the interim people, the contractors getting in, are actually entrepreneurs, because there's not much of a business risks for these entrepreneurs. So this is actually what I wanted to talk to you about, the Uber case, and that brings me now to Nilovar, who will tell you more about the do's and don'ts on non-compete.
Thank you, Maarten. Thank you for your interesting story. If anyone has any other questions, please feel free to ask them. So the non-compete, it's a very important clause, and it's becoming more and more important because we have a very tight employment market right now.
Yes.
And it's being used a lot. And I will come to that subject later on. Mm-hmm. But to begin with it, the competition clause is intended to protect employees' assets and not intended to bind an employee to your company. And it happens a lot. A lot of employers put a non-compete clause in their agreements standard without even checking if it's valid or not, because they want to keep their employees to themselves, which is quite understandable, but it's not the way that this clause was intended. And there are a few important aspects of the competition non-compete clause. The first one is that in principle it is only allowed to add a non-compete clause to contracts that are for an indefinite term. So that is the general rule. But in a fixed term contract, sometimes it can be necessary to add a non-compete in it. But there have to be compelling business or service interests. And those service and business interests have to be substantiated and have to be added in the contract. This means that it has to be very clear why the non-compete is being added in a fixed term contract, and it has to be clear upfront. This means that an employer cannot add a non-compete or non-compete can be add the substantiation of their compelling business interests at a later stage, because the employee needs to know why he or she is signing this. Another thing that is very important to know is that a relationship clause is also often added in non-competition contracts together with a non-compete clause, but sometimes on its own. But it's very important to know that that is 9 times out of 10, I think, the same as a non-compete.
It's considered non-compete.
It's considered a non-compete. And that is because you're still restricting an employee to go work for certain certain business relations, which will also be considered a non-compete.
Yeah. It's still different, isn't it? Because if you limit an employee to work for clients or the relations of the company, is something completely different than actually limiting someone to work.
Exactly,
isn't it?
Exactly. It is, but in some cases, I can imagine that it is the same as a non-compete. In some areas of work, you always see the same companies. So if you have a non-compete in the first, then maybe you cannot find a job easy, or I don't know, at another company. At the end, it's a restrictive clause, and because we have the freedom of employment choice, employers must be aware that they are restricting an employee to find another job elsewhere. So another very important aspect of the non-compete is that it has to be in writing. And the burden of proof lies with the employer. If an employee says, well, I did not know that I had a non-compete because it was not clear to me, then the burden of proof lies on the employer who wants to enforce the non-compete to demonstrate that they informed the employee about the non-compete, they have given the employee sufficient time for consideration, and the employee has consciously agreed to a non-compete clause. So in short, it needs to be a signed agreement and explicitly referring to a non-compete. This doesn't mean that it has to be in the employment agreement. It can also be in an employee handbook. But it's very important that the reference to the employee handbook is clear, and the employee handbook is also attached to the employment agreement. So again, it needs to be a very informed consent, because it's limiting the employee to find a job elsewhere. And also a little side note, non-competes are not allowed in collective labor agreements.
Probably not accepted either.
Yeah, yeah. When a non-compete is agreed upon, there are possibilities for the employee and also, in some cases, the employer to take action. So you have the employee that can take action to limit the effect of the non-competition clause, and there are a few possibilities. So you have grounds for annulment. And in a fixed-term contract, that is very clear. There are no compelling business reasons. But it can also be that you never even added the compelling business reasons. Another aspect can be that the non-compete unfairly disadvantages the employee. Well, you can say as an HR professional, well, they signed their employment agreement and they knew they signed a non-compete. Well, that is very true. But in some cases, an employee gets a very nice job opportunity and really wants this job. And And getting this job will mean a lot of more incomes or more, stability for the employee, or it's something that they want to do all their life, etc., etc. There can be compelling reasons for a judge to say this non-compete unfairly disadvantages the employee, and I will annul the whole non-compete. Mm-hmm. It's important to know that this has to be done through the courts. So there's always quite a, how do you say, drempel?
Well, how does it work? How does it work? How does an employee, how can he be able to have it modified? How does it work?
Yes, they have to go to the sub-district court, kantonrechter, and request that this non-compete will become annulled or become moderation. So maybe some changes in the geographical scope or in the time that it takes, or even in clients. An interesting fact is that the judge can say that this is a very long time to restrict someone, and I will make sure that it becomes shorter. This doesn't mean that the whole non-compete will become annulled or null and void. No, it becomes only less burdensome on the employee. Generally, it is accepted in the Netherlands through case law that a duration of 2 years and more is generally unfair to the employee, and most likely will become shortened.
Seems difficult. I mean, first you, as an employee, you sign non-compete, and then let's say, would you start such a litigation during employment, or would you advise them first leave the company and then see what happens?
So that's a very good question, and that also depends on all the facts around the case. There is case law where an employee has been given a job, they accepted the job and they want to start the job, and they hear from their employer, no, we are going to uphold the non-compete. This means that you cannot accept this job. Then you can go to court at the kort-geding, so that means a summary decision to ask if it can be amended. And in some cases, if you want to be very sure of your position as an employee, it can be better to ask them during your employment. So it's very relevant. Yeah, the facts of the matter are very important.
Yeah.
But there are also cases where employers and employees just start conversations and they say, okay, well, if you don't work for client A, B, and C for the coming year, then we will accept that you leave the company and go work. So there are a lot of possibilities, but the main issue is that the employee has to go to court. And you can imagine that if you are an employee and you are in very need of a job, that it can become hard to, during your negotiations of the contract, to say, well, I don't want this non-compete clause. A lot of people just sign it. To be fair, I understand, because if you need a job and the income, you have to. But then also the situation comes up or rises that you want to get another job and you have to go to court, which comes with costs and a lot of stress for a lot of people. Significant changes to the employment contract also require explicit reference to the non-compete clause. So there is case law available where an employee had a fixed term contract with a non-compete, but not with the substantiation of the business reasons of the non-compete. Then he gets an addendum and he gets a contract for indefinite terms. In that case, it's very important to again acknowledge that there is a non-compete, and this time that it will that it is still part of the employment relationship. Sometimes a non-compete clause that was valid can become partially or fully invalid in some cases. When it's a case of, for example, overgang van onderneming, transfer of enterprise. If it's a transfer of enterprise, the non-compete stays valid because everything stays the same. But if it's not a transfer of enterprise, in some situations, the non-compete can become invalid. So it's very important to, if there are changes in the employment relationship, to have a little alarm that goes off in your head to check if there's a non-compete and if it's still valid.
What about regular promotions?
Regular promotions don't affect the validity of the non-compete, but if it's irregular, for example, a very big promotion, you go from junior to senior in one step because someone left the job and it was an opportunity, etc., etc. These are unforeseeable circumstances that can lead to invalidity of the non-compete contract. Also, there's this increased burden criterion, and that applies when changes significantly restrict the employee's job opportunities. And that is what we were just talking about. So that is that can be a significant unforeseeable change in a job role. But it can also be that the company is expanding, which makes their working scope, a geographical scope, larger. And then maybe they go from 2 branches to 10 branches, and then the employee cannot find a job in his sector anymore. These can also be factors to be taken into consideration when assessing if there's an increased burden for the employee.
So, for example, if you have a medium-sized company which is taken over by a big group of companies internationally, that might affect the scope of the non-compete, and therefore that might lead to renewing the non-competes. Yes,
exactly. Okay. Exactly. So if this company was only working in the Netherlands and now is, let's say in Amsterdam, and now it's opening branches in Utrecht, in Den Haag, in Groningen, etc. And the non-compete it has a scope that it says a geographical scope, 10 kilometers around every branch. Then it can become very burdensome for an employee to find a job. Also interesting, an employer cannot derive any rights from a non-compete if the termination or non-continuation of the employment contract is the result of serious culpable actions or omissions by the employer. So wrongfully accusing the employee of something, or causing a disruption in the relationship that is caused by the employer. These can also lead to the non-compete being invalid, because it's not fair to restrict an employee, and in the case where also the employment relationship ended due to culpable behavior of an employer. Okay. So it's important. There's also the possibility for when an employee goes to court to ask for a compensation for the duration of the non-competition clause. It is not a very used part, I think, because there is not a lot of case law available.
No.
But we do have a case example. This is about an employer that operates a restaurant and a bar. And this employee was hired as a DJ in 2013 with a competition clause. The employee resigned 3 years later, but already has been working freelance at a competing restaurant and bar in the same street. The employer sued for enforcement of the non-competition clause, arguing that the employee's work at the competitor harmed its business. Well, we have a poll question for you, and that is the employer required to compensate the employee according to paragraph 5, section 600, 503, 53 of the Civil Code in this scenario. Please take your time to give an answer, and then we'll go to the next slide and see if this DJ was compensated.
So, and tell me, if compensation is the case, what kind of compensation are we looking at?
Well, that is a fair compensation. So the judge will take into account all the factors that are important for the calculation of said compensation, and that can be the duration in which the employee cannot work, the amount of income that he or she is missing because they cannot accept a certain job that they want to take. So all these factors are taken into consideration by the judge when assessing if there is room for a compensation under this clause.
What do we see? If we do have a little case law. Are we seeing high amounts? Are we seeing low amounts?
No, it's not a lot. It's quite low amounts, and yeah, I don't know why, but the judges are quite they're not very keen on it. But also, It is quite a hurdle to take for an employee to go to court and then also ask for compensation that has to be substantiated.
Yeah. But employees probably will go first. They will request the court to grant modification.
Yes.
Or annulment.
Yes.
And if they don't get it, then pay me compensation.
Exactly.
Isn't it?
Yeah. Exactly.
So you could say that if annulment is not granted and modification is not granted, then it's probably a valid and reasonable non-compete. And then apparently in the Netherlands, there's not much room then for this compensation.
It doesn't happen often, and most of the times the judge just modifies the clause for the scope that becomes smaller, or the time frame, or the geographical scope. So there are a lot of options.
Okay, when do you think that we know the answers to the poll?
We have the answer to the poll.
Great.
So 67% answered yes, and 33% answered no.
So let's see.
So, well, first the sub-district court that ruled in favor of the employer enforcing the non-compete, but partially suspending it, which happens often.
So there was a modification.
There was a modification, but it wasn't sufficient for this employee.
Okay.
The Court of Appeal, and I will first talk through the considerations.
Yep.
And this is, I think it's very interesting to see how this DJ can be of importance to a company. So he was not the main face of the employer's company, but he played a key role in attracting customers. Apparently, he was very popular. And since the competitor was in the same street with the same business model at similar hours, it is a direct competitor. And it was a real risk to financial harm to the employer, because this employee brought in clients, and it could be the case that when he is DJing at the competitor, that all the clients will move to the competitor. So the court considered the employee's actions as unfair competition, and because he was leveraging his popularity gained at the employer's business to benefit the competitor.
Yep.
Well, the final judgment, the court acknowledged that the employee struggled financially after leaving the employer, but the employer, he had a very strong financial interest in enforcing this non-compete. But yes, the employee was significantly restricted in earning a living. And, well, you should think that being significantly restricted in earning a living would become a significant compensation, but that was not the case. 450 euros gross per month as a compensation. And the considerations were the lower earnings of this employee and lost income opportunities. So yeah, I found this court case quite dualistic, because at the one hand, yes, you lose a lot of income, but then the court only provides a very small compensation, if I have to say.
Yeah, but that is because I assume this was also, there are small employers.
Yes.
So if they would have to pay this DJ who left by himself, isn't it? Also in a huge amount of money.
Yeah.
You might.
Yes, I don't know what.
Doesn't seem fair either, does it?
No, that doesn't seem fair. And this is the balance that we have to keep with these non-competes in our work, but also in HR, that there are so many factors that play a role when agreeing on a non-compete, but also when someone leaves and starts a new job at a competitor.
Yep. All right. So 67% said yes. Well.
Yeah, that's a lot. Yeah. So research shows that 1 in 3 employers uses a non-competition clause almost as a standard clause in the contract. And we know now that that is not what was intended. And there's not always a good reason for this. Now, for example, the employee does not have access to relations or sensitive information. If you are just merely driving a PostNL car and bringing packages, there's no need for a non-compete. Meanwhile, it can also have an effect on the employees because they are maybe afraid to transfer to another employer. And again, because they have to go to court to enforce something if the employer doesn't cooperate, it can be quite hard financially, but also mentally, I think, for an employee to get this non-compete restricted. So an estimated 3.1 million employees are bound by a non-competition clause.
That's a lot.
That is a lot, yeah. But there's hope.
For the employees then.
There is some hope. No, but also for clarity. Okay. There is a reform coming on the non-competition legislation because the government wants it to be clearer in advance when a non-competition clause can be included and invoked by an employer, which will, I think, result into less discussions and also less court cases about this subject. Well, there is a bill to restrict the non-competition clause, and it has a few key restrictions. First of all, it can only be for 1 year max. So no more 2-year, 3-year non-compete clauses, which I think is a positive change. And the territory in which the employee may not work must be clearly defined. So there has to be a geographical scope. Sometimes in current non-compete clauses, sometimes they are not. There's not a geographical clause, and that can also become troublesome for the employee.
Once I saw a non-compete from a US company who actually limited this territorial scope to the universe.
Oh,
so
very American. No. Also, the compelling business reasons that are now must be added into a contract for a fixed term amount of time. The substantiation has to be in every contract. So even if it's an indefinite contract, there has to be a substantiation on why the non-compete is necessary. What are the significant business interests for a non-compete clause?
So it will be for all non-compete clauses, whether or not it's a fixed term contract or an unfixed term.
Yeah.
So all the same.
In that sense, it becomes clearer also.
Yeah. It's still difficult because when you start a non-compete clause in the beginning and then someone has been employed for 9 years and then you've got another role, companies changed. How do these two then? Yes,
and that is the hard part, I think, of the non-compete because employers are not always updating their employment contracts and addenda. They try to run a business. But it's very important for HR to know that if something changes in the business, in the employment relationship with an employee, that there's always a check on the non-compete and if it's necessary or not. Sometimes it can be necessary to add a non-compete later on in the relationship when an employee has worked himself or herself up to a certain position where a non-compete becomes necessary. So it's a very dynamic subject, I think.
So an advice would be for HR to have regular updates.
Yes.
On contracts and also on the whether or not the non-compete is still should be in place, or
exactly
if a non-compete should come
into place. Yes, yes, agreed. Under the new legislation, if it becomes legislation, an employer must pay compensation to the employee with a non-compete when a non-compete clause is invoked. The compensation will be at least 50% of the last monthly salary earned for each month that the non-competition clause is invoked. So that can become a significant amount.
It's completely different than what we saw in this court case, isn't it?
Exactly. So it becomes the opposite situation, which protects and creates some clarity, but also gives the employer time to reassess if it is indeed necessary to invoke this non-compete clause, because it will cost money. So there will be a more balanced
so it strengthens the position of the employee, more or less. Because
it strengthens the position of the employee, but I think also for an employer, it is good to reassess if a non-competition clause is even necessary for when an employee is exiting.
Yeah.
So it can become also part of an exit conversation that HR always keeps with their employees when they're leaving, to see, okay, well, there is a non-competition clause, but we are not going to invoke it. We will send you an email and to declare that we are not using it.
But it's easy. But under the current legislation, it's easy to keep employers to their non-compete.
Yes.
And under this possibly new legislation, it will be the employer will have to make a more careful assessments because of the financial impact.
Yes, exactly. And it can also be that an employer has a non-compete in the contract for example, a year, but decides, because it's better for their business, to only uphold it for 3 months, 4 months, 6 months.
Let's see, a question here from Alistair. For a sales role, would this include commission as well as a basic salary? I would say yes.
I would say yes as well, if it is
then probably a
standard
average
commission. Yeah, yes, exactly, an average.
Yeah.
Well, what is the status of this bill? The Ministry of Social Affairs finalized the annual planning of 2025, and according to this planning, the non-compete clauses will not be submitted to the House of Representatives until Q4 of this year.
So that means maybe in Q4 we'll have
more information.
More information on this.
Yeah, exactly. But the reform will not take effect before 2027.
Okay.
It's the most realistic scenario.
So tell me a bit more about this 50%. Where is this 50% coming from?
Well, Bart, that's a very good question. I think they were inspired by our neighbors because in other countries, they already have these kinds of legislation. So in Germany, the employer pays a compensation to the employee in case of a non-compete, and it's at least 50% of the last year's salary. If the employer doesn't pay, the clause becomes invalid. In Belgium, they have a similar regulation, 5 conditions. The employee's salary must be relatively high. The non-competition clause must relate to similar activities.
So not for relationships clauses.
Yes. It must be geographically limited, as the proposal is now in the Netherlands. The non-competition clause is max 12 months. And the compensation is is equal to half of the employee's gross salary when it is becoming applied. So that can become a longer time or a shorter time.
Yeah. It's still difficult when you look at this non-compete clause in the Netherlands. If you look at this intended legislation, the 50%, because you mentioned that relationship clauses can be considered a non-compete as well. So that means that as an employer, I would be due 50% of the salary in order to avoid that such a guy is taking all my clients away.
Yes, that is a very good point. I expect to have, I think, more clarity on this subject maybe in Q4, because it is valid. If you put in a non-compete or a relationship clause, they will be qualified right now under case law under the same umbrella. Yeah. But I think it would be,
especially because the Netherlands, we, of course, our economy, we have a lot of service companies.
Exactly. Yes. So that can also be one of the amendments that will maybe be made, that the relationship clause will be excluded, but that is not clear yet.
Okay.
Well, I think we are at the end of our presentation. Are there any questions?
Well, for now, I think we've seen all questions risen have been answered. Meaning that, well, in the end, actually, we are now at the end of our HR Quarterly, and that means that we thank you for your attendance. There is a webinar evaluations available, and one thing I would like to address is that there will be a live event to be held in September. Please feel free to enlist and keep noticing our website for more information on that. Thank you very much.